So good morning, everybody, or good afternoon, I guess. Welcome to the IDC CLE today. We are pleased to have Adam Bevis with us from the Office of Professional Conduct. And one of the core principles of the Utah Indigent Defense Commission is rule number 7, which states that representation must be free from conflicts of interest. And today, Adam will be talking about the rules of conduct and with special attention on conflicts of interest and how to avoid violations regarding conflicts of interest and how to fulfill our duties to our clients when it comes to providing zealous and conflict-free representation. He graduated from the University of Utah College of Law in 2003 and has been working with the Office of Professional Conduct since then, first as an assistant counselor and now as deputy senior disciplinary counselor. And he has been involved in investigations and prosecution of thousands of disciplinary cases and handles a large portion of the office's appellate work before the Utah Supreme Court. So he has seen it all and can provide great information to us about conflicts of interest and how to avoid them and how to make sure that our clients get representation that is free from conflicts. So I turn the time over to you, Adam. Thank you for being here.
Oh, thank you. You're welcome. It's always a pleasure to talk to a group I haven't talked to before. So pleased to be with you all today. Just to give you a little roadmap of what I want to cover. I do want to pay special attention to the rules of professional conduct that have to do with conflicts of interest. So those are going to be rules 1.7 through 1.10. So I think we'll begin by discussing those kind of in depth and talking about special applications to public defenders or special things one should be looking out for as a public defender with regard to the conflicts rules. This hour also counts as professionalism and civility credit. So in the second half, I do want to talk about the standards of professionalism and civility, talk about how some of those standards actually overlap with the rules of professional conduct for the ethics rules, so that you can get credit for the professionalism and civility portion of the CLE. Like she said, I've been with the office for a long time, 17, 18 years. So I have seen a lot of cases come through, a lot of allegations and a lot of prosecutions. So please ask questions throughout. I think the Q&A feature is working and I will try to check on that throughout the presentation, not just at the end. So I hope I can answer those kind of in real time, but if not, I will try to get to them all at the end. So just to give you a little bit of information about how the Office of Professional Conduct handles complaints that deal with conflicts of interest. We do get a lot of complaints that allege that. Maybe it's not the only thing someone is alleging in their complaint, but it's a component of their complaint. And truth be told, most of those allegations of a conflict are unfounded, or even if what they're alleging is true, wouldn't really be a violation of the rules of professional conduct. And I'll tell you why. It's because the general public, lay people, don't really have an understanding, I think, of how specific the ethical obligations are for a conflict of interest violation. For example, you'll get a complaint, someone's mad at their defense attorney, someone's mad at, their divorce attorney because they saw them talking with opposing counsel or talking with the prosecutor in the hallway, and they seem to be joking. And obviously this means that they're friends and that they can't be giving their full attention to the client, and they're in cahoots. Cahoots is a word that comes up in our complaints in these situations. And, that's not a conflict of interest. We all know that, but they don't. They think it divides your loyalty. They think that perhaps you're not giving them the best representation that you can because it looks like you're friends with the other side. I tell people at this point that one of the best things you can do, and something that's kind of covered by the professionalism standards, is that at the very beginning of representation, kind of walk through your duties under the professionalism and civility standards, because those duties place an obligation on you to be courteous to the other side, to be cooperative. And I think if your client hopefully knows up front that if you are being cooperative with the other side, for example, they asked for a 2-week extension and you grant that, it's because that's how you practice law, and because these standards of professionalism and civility kind of compel you to practice law that way. That it's, I know a lot of you aren't working on the Wasatch Front, so you're out there, smaller communities. Of course, you're going to know everyone in the legal community there. And if you run into them at the courthouse, you might exchange some pleasantries with them, but that doesn't mean that you have a conflict of interest. That doesn't mean that you're compromised as far as representing your client. So if you can set those standards and put those kind of ideas in your client's mind at the beginning of representation, it might avoid some of the complaints we get where someone's alleging a conflict of interest. It might not too, but like I said, those sorts of complaints don't really go anywhere. They get dismissed because even if that's true, it's not a violation of the conflict rules. But it is a good idea to try to set those expectations in your client's mind up front. Sometimes we also won't intervene in conflict allegations if there's a motion to disqualify pending. We'll wait and see what the court decides on that. And we don't always agree with the court's outcome on things like that. I think courts generally are more conservative as far as disqualifying an attorney if that allegation is raised, sometimes more so than the rules require. So just because you may have been disqualified from a case based over an allegation like that, if there's also a pending complaint in our office, it's certainly going to be a piece of information that the court has decided to disqualify you, but it may not be the controlling factor in that investigation. So they don't always end up that way just because the court has decided that there was a conflict of interest. And sometimes if there is a malpractice action which is being contemplated or is pending based upon the harm that came from a late discovered conflict of interest, we'll defer to that forum and invite a complainant to return to us after that is complete. Or we'll just put the case in abeyance until the malpractice litigation plays out. Because really the remedies they're looking for are better served sometimes in that malpractice forum than they are through a complaint with the Office of Professional Conduct. So I hope it gives that some idea of how the office views these. We do get a handful that are legitimate and do go through. Luckily, I'll say that most of the conflicts of interest cases that we see are negligent conflicts. They're not somebody intentionally, knowingly entering into a conflict of interest because they just don't care. It's people that have performed a poor conflicts check, forgot they had a client a couple of years ago that now they're adverse to. So things like that level of negligence, which generally doesn't equate to serious discipline under the rules. So I'm glad that when these things do happen, they're generally mistakes, but let's talk a little bit about some of the ways that we can try to prevent those mistakes so that there isn't even a negligent violation. The first conflict of interest rule is 1.7 of the Rules of Professional Conduct, and that rule discusses concurrent conflicts of interest. So parties who are directly adverse to each other, which should be obvious for everyone. You can't represent both sides in a divorce case, something like that. It also covers situations where you have your own material reason why you would have a conflict of interest in a case. It could be a personal reason, but it covers those situations as well. And there is a long section of 1.7 which talks about what you can do if there is a concurrent conflict of interest and in what situations you can have that waived. And in certain situations, you can have a conversation with your client where they're able to waive the conflict of interest. Their waiver, I'll say, some conflicts are unwaivable, but some of those are going to be waivable if you can get the informed consent confirmed in writing from your client. And that's important because your client needs to understand the risks that they are undertaking if there is a looming potential conflict of interest or if you have one right off the bat. And that all needs to be documented in writing. They need to understand it and sign it. Because I have seen conflict waivers where the writing basically just says that they agree to waive any conflicts of interest. That's insufficient under the rule. That's not informed consent, which is defined by the rules. And, and it's not specific enough to accomplish the goals in explaining things to your client and having them actually give a informed waiver of what the conflict might be. Because the repercussions of a conflict coming up later can seriously impact and delay their case. If a conflict comes up later, which requires your withdrawal, then they're going to have to try to obtain new counsel, get continuances in the case, perhaps start over with another attorney, which are all significant impacts to whatever they're facing, which is required now that they've lost an attorney because of withdrawal. So 1.7 kind of gives you what you need to do to protect yourself in those situations so that you can actually get their informed consent confirmed in writing and proceed with the case. One section of 1.7 that I think is really important that I would invite all of you to revisit and read is the comments to 1.7. In particular, there are lengthy comments after 1.7 that deal with co-defendants in cases, and the certain risks that come up with representing multiple parties in the same case that might all have common interests. And basically, to sum up what the comments say, it can be done, but there are multiple risks with doing that. Some of the things that you need to keep in mind when you have co-defendants in a case, you need to inform them of course, the potential conflicts of interest. You need to get their informed consent in writing. You need to tell them about 1.6, your duty of confidentiality. If you, let's just say you're representing 3 people that were in a car that was pulled over. You need to explain to each of them that anything any one of them tells you, you need to pass on to the other 2. And so that right there can often, make it obvious to the clients that common representation isn't going to be a good idea for them, depending on levels of culpability, what happened, who wants to cooperate, who wants to try to fight things. So I think it's really important to review the rules every now and then, but the comments to 1.7 I think are even more helpful than the rule itself. They give some real life situations that you might encounter that might make you think twice about entering into that sort of representation from the get-go, just for fear that eventually it's going to explode at some point. And even if you've taken the time to jump through hoops and try to explain everything to everybody of your clients, they might still file complaints. It still might cause you a headache later on down the road. So reread those rules. I think they're really helpful. I'll tell you which, I have it up here. So there's multiple paragraphs after 1.7, but the co-defendant part starts at, paragraph 29. So I would at least read those sections if that comes up in your practice, just to have that fresh in your mind about what sort of information you need to be giving your clients if they are co-defendants. I think 1.7 is fairly obvious to people. We don't get a lot of situations where attorneys are attempting to represent adverse parties in the same thing. So, because you would kind of know that you were doing that. It's not the things where it comes up, like I said, is generally when it's a negligent thing, because the attorneys failed to perform a sufficient conflicts check or something like that. So I want to talk about conflicts checks a little bit more under 1.9, but keep that in mind for now. Rule 1.8 is the next conflict of interest rule. It's kind of a catch-all for all the various kinds of conflicts of interest that attorneys can get themselves into. And it may not come up, many of the provisions may not come up much in public defender situations because they involve things like entering into business transactions with clients, getting book rights to a client's story, things like that, loaning clients money, that might come up. Attorneys now are allowed to provide a little bit of money to clients, not to fund their litigation, but with indigent clients, you can provide some financial assistance to them, so that they can make it to a library to use a computer, things like that, so they can adequately communicate with you. if that comes up in your practice, that's not completely barred under the rules any further. Rule 1.8 also has the don't have sex with your client rule, which hopefully doesn't apply to anybody that I'm talking to, but is one of the more entertaining rules to investigate at the Office of Professional Conduct. So, I started a long time ago, and we would get allegations that attorneys were engaged in sexual relationships with their clients. Often in divorce cases, a spouse would say that, I think my soon-to-be ex is in a romantic relationship with their attorney, or I don't think my soon-to-be ex is paying for legal services because they're dating the attorney. And it was always generally like an evidentiary problem. We had a hard time proving any of that. And so those cases didn't really go anywhere. As social media has picked up in the last few years, it's now sometimes easier for people to provide evidence with their complaints, such as pictures of the attorney and the client on a beach vacation, things like that, which kind of help bolster the credibility of their allegations. Doesn't happen a lot, fortunately, but I would encourage all of you to avoid that rule. I do have a couple of, whenever I talk about Rule 1.8, there is a case that I like to talk about because it amuses me. There was an attorney named Thomas Lowe. It's not in Utah, and I actually forget which jurisdiction this was in, but he lost his license because he was engaged in a sexual relationship with a client. And what happened was he took on a divorce case. He began communicating with his client, the female, about whether or not she'd be interested in a sexual relationship. So the representation started first. Whenever that happens, it's presumed to be a conflict of interest under the rules. My favorite thing about the case, though, is that they did end up having a sexual relationship, and he ended up billing her time for the time that they spent together. So in addition to violating 1.8, there was also an excessive fee issue in the case because he was billing for their time together, which just always amuses me. One case under 1.7 that I forgot to mention that I think is also worth mentioning. This is also not from Utah, but it was an attorney who was having an affair with his client's wife while he was representing the client for a murder charge. And the conflict came out a few years after his client had lost and been sentenced. I think it came out in the appeals process somewhere. But the argument, of course, was that he's having a romantic affair with his client's, who's incarcerated, wife. If that's working out for him, he has no incentive to make sure that his client's found innocent or not found guilty. And that was the argument that they used on appeal, and I think they ended up getting a new trial out of that. So kind of just egregious conduct. Haven't had a case like that here in Utah, which makes me happy, but they're not hard to find when you look nationwide. So the next conflict rule, oh, I see, let me try my Q&A thing here. Oh, it's answered, okay. The next conflict rule I wanted to talk about is Rule 1.9. Rule 1.9 talks about conflicts of interest for former clients, basically. Somebody you've represented in the past, and now you have a new client who might have something adverse to them, and whether or not you can represent the new client adverse to a former client. As you can imagine, we do get a lot of complaints in that area because somebody thinks, well, he or she was my attorney, 6 years ago, and now he's got a client that's suing me for something. That can't be right. Well, 1.9 is actually fairly narrow, narrowly tailored in these situations. And it has to be someone who's adverse to your former client in the same or substantially same matter. And there also should be a showing that they are using confidential information they learned during your representation adverse to you now. And so if they're completely unrelated matters, there's generally not a 1.9 violation, unless there can be some showing that they're now using confidential information against you that was only learned because of the previous representation. But if the factual basis for the matters is completely separate, there's not a tie there, the fact that your attorney once represented you and is now adverse to you is not necessarily a violation of the rules of professional conduct. And this is one of those areas where I think courts can sometimes be more conservative in their interpretation of the rules than we are, just to make sure there's not even the appearance of a conflict of interest. I've seen attorneys get disqualified for this reason, even though there's pretty solid evidence that they're not using previously learned confidential information. They're not adverse to each other in the same or substantially related matter. But this is a big area where having sufficient conflicts checks is going to prevent all of these situations. I've realized with this group that you might not have the resources, probably don't have the resources of middle or large firms that can, have a robust software program that does conflicts checks for them. And it might just be you running the show. I still encourage you strongly to maintain some sort of spreadsheet, see if you can get some software that does case management or case tracking so that you can enter people's names into it and try to run a conflicts checks before you get a new client or agree to take on new representation. It doesn't have to be something fancy. It just has to be something where you can type in former clients' names, a little blurb about what it was about, just so you can remind yourself when you get a new client, you can run through that. It's also important to put prospective clients in that conflicts checks too. Under Rule 1.18, somebody that comes to talk to you, somebody you just have a brief meeting with, maybe even not somebody that you ever form an attorney-client relationship with, you do owe them certain duties. And one of the duties is the conflicts duties, and the confidentiality. So having that information in there, because you might not even remember discussing something to someone for 20 minutes, a year later. Having that information in a searchable spreadsheet or other management software so that you can actually refer to it and avoid a conflict will keep you out of all of these problems. I know that's tough when you don't have all the resources that a larger firm might have, but it's not enough to try to rely on your memory. That's just going to open you up to some negligent conflicts down the line. So I know we all like to think that we have incredible memories and we can just do it that way, but I know I don't. So I would encourage everybody to try to do as robust a conflicts check as they can.
Can I make a comment?
Yeah,
the IDC does provide defender data case management system free of charge to attorneys. So if you are interested in that, you can contact IDC to get more information about that system and how we can help you get it.
That's great. And I would strongly encourage all of you to do so. Just having something, even if it's just names, will really help prevent a lot of these problems, especially in your line of work. I mean, I would imagine that you have a lot of cases and some of them move through fairly quickly, and you're not going to be able to remember all of those things as the years go by. So try to keep that in mind. Try to make that more of a priority in your practice if it's not right now. And I think if you have had conflict allegations or you have gotten yourself into trouble with conflicts, I really think you'll be able to avoid some of those things if you just have more of a robust conflicts check system in your office. Rule 1.10 is a conflict rule that talks about imputed conflicts of interest. And I don't know how many of you are working in firms or how many of you are solo practitioners, but it's the rule that applies to people who are working in firms. And it basically says if one of you has a conflict that would prohibit you from the representation if you were solo, then all the attorneys in the firm share that conflict as well. So if you find yourself, if you do have a partner, you do have a firm, and you find yourself with a conflict of interest, you probably aren't going to be able to pass that case on to somebody else in your office. The entire office would be prohibited from entering into that representation. So that's important to keep in mind if that's what your practice is like. If you're a solo practitioner, 1.10 doesn't really apply to you. That covers, I think, the heart of the conflicts of interest rules that are in the rules of professional conduct. And as we know, those are the ethical rules that actually lead to sanctions if you violate one under the standards for imposing lawyer sanctions. The professionalism and civility rules that we're going to talk about, there is a link in the rules of professional conduct where multiple or egregious violations of the civility rules can lead to a sanctionable complaint under the rules of professional conduct. But I think we all remember when the standards were introduced some time ago, decade ago, I think a lot of people thought they were merely aspirational because they didn't really have any teeth to them. But there is now a mechanism in the rules of professional conduct which covers, like I said, egregious and repeated violations of those rules. So I want to move into talking about those. But if anybody has lingering questions about a conflict of interest, please put it in the Q&A. I'll try to get to it at the end before we're done. I do have a PowerPoint about this next section, so I'm going to see if I can get that to play with all of you. Okay. I apologize in advance. This PowerPoint is a couple of years old and I wasn't able to edit it on my home computer here. So I'll point out the sections that need to be updated. It's not significant to the substance of the PowerPoint, but some of the dates are a couple of years old. So like I said, the professionalism and civility standards were rolled out by the Supreme Court a number of years ago to try to make the practice of law in Utah a little bit more enjoyable and reduce some of the adversity, unprofessional adversity that I think was a growing trend in Utah. It wasn't uncommon for us to receive complaints where somebody had just behaved horribly, just awful behavior, but it wasn't an ethical violation. And there wasn't anything we could tell complainants. Sometimes it was, just opposing counsel and was just getting beat on by their opposing counsel. So with that trend in mind, the court adopted the professionalism and civility rules to try to, I think, remind everybody about their obligations and to try to rein in some of those bad actors that none of us wanted to work with, that had a reputation, and was really, making the practice of law kind of miserable. I'm not gonna read all of the standards. I've got them summarized in this, so a little bit more brief. But just so we're clear, there's a few sets of rules at play that we're talking about today. So we've already talked about the rules of professional conduct. That's the ethical rules that my office investigates and prosecutes where necessary. Those are the rules that actually lead to sanctions, from private admonitions all the way up to disbarment. The rules of lawyer discipline and disability there at the top, those are the procedural rules that cover all of this stuff. They cover how to file a complaint, they cover how the prosecutions work, everything like that. The incorrect thing on this particular slide is that they were all renumbered in December of last year, so just a few months ago. So it's no longer Chapter 14, Article 5. They are now found in Chapter 11 of the Supreme Court Rules of Professional Practice, if you go looking for them. So note that, please. The standards for imposing lawyer sanctions are the standards we use once there is a finding that somebody has violated one of the rules of professional conduct. It's at that point that you evaluate what their mental state was. Was this a negligent violation? Was this a knowing violation? Was there harm? Was there potential harm? And you weigh aggravating and mitigating circumstances to see if the presumptive level of discipline should be ratcheted up or down based upon aggravation and mitigation. So that's what the standards for imposing lawyer sanctions are. Just for your own curiosity, if you have curiosity, these are the most commonly alleged violations. It's usually competence, diligence, communication, because lawyers stop talking to people, getting overcharged, and then attorneys engaging in some sort of conduct under 8.4 B and C, which is, those are the rules that deal with deceitful conduct, misstatements, lies, things like that, or criminal conduct under 8.4b, attorneys engaging in criminal conduct. So these statistics are a couple of years old, but the trends haven't really changed all that much. As far as the rules that actually get violated, rather than just alleged, we're most of the time dealing with communication, safekeeping property that's in trust account, diligence, competence, misconduct, ending representation. We have a lot of problems with that when attorneys don't refund unearned funds that are in their trust account or return the file. And I say to you all, that's probably the most common place I see it in criminal matters, is the representation's ended and somebody is alleging that you've not returned a file to them, or they've requested certain documents from their file and they're incarcerated and they can't get them. I understand sometimes they're requesting documents that you can't provide by statute. So we're mindful of that, and that comes up in the investigations. But oftentimes it's just attorneys haven't returned a file to a client after things are over. Fees you might not have to deal with. Dealing with your non-lawyer staff because one of them may have engaged in something unethical without your supervision, but you still might be on the hook for that. And 1.2 is the scope of representation. Sometimes attorneys who engage in limited scope representation don't fully explain that to their clients. It's allowed, but your client needs to understand what parts of a certain case that you are their lawyer for and what parts they might still be on their own for or need to seek different counsel. The discipline imposed a couple of years ago, just to give you an idea, we probably go through 1,000, 1,100 pieces of information that come into the office every year. And of all of that, 2 years ago, it boiled down to this level of actual discipline imposed. The vast majority of our cases are investigated and don't reach the level of discipline because they're dismissed or declined because they were meritless to begin with, or meritless after our investigation is complete. We can see admonitions, public reprimands, suspensions was kind of high that year, disbarments, and then sometimes throughout the process, the attorney will just elect to resign with discipline pending rather than go through a district court case. So those have to be accepted by the Supreme Court. That's not just an agreement with the Office of Professional Conduct, but the court can just accept your resignation rather than face the disciplinary procedural hearings. So the standards of professionalism and civility, like I said, in some cases overlap with the rules of professional conduct. If you're violating one of the rules of professional conduct, you're probably also violating one of these standards of professionalism and civility. It doesn't come up a lot in the conflicts section, but I have highlighted some of the places where they do overlap, and I'd like to talk about those. Let's quickly run through, just as kind of a reminder, what the standards are. First one is lawyers should not reflect any ill will of the clients. That kind of relates back to, when I was talking about running into opposing counsel or something like that in the elevator of the courthouse or out in the parking lot, and your client might be really mad at that person, but try not to be overly friendly because then they think you have a conflict of interest, but you shouldn't be reflecting the ill will that your client has. You're supposed to be the professional intermediary in those things, and it's not necessary for you to make their feelings in their case your own. So I would urge you to be courteous at all times. Sorry, let me move this. Like I said, telling your clients up front what your duties are under these standards can sometimes alleviate their concerns or their desire to file a complaint if they understand why you're doing things, why you might give an extension even if they don't want you to. Not something that's going to prejudice their case, but just the basic extensions that we all kind of need here and there just for another week to finish something up. Attorneys shouldn't attribute an improper motive to the other side unless it's actually based on some evidence. For example, if the prosecutor does something in a case and your client's upset about it, don't immediately jump on board and say, well, they're just doing this because personal grievances or because they hate you or something like that, unless you actually have a basis for that. Don't attribute positions to people who haven't actually taken that position. Let's just run through some of these a little faster. Try to keep any promises that you make to your client. I know that none of you probably are guaranteeing any results up front. Clients always think attorneys are. I would have that in a fee agreement or an engagement agreement that you have with your clients, that results are not promised or guaranteed. Watch yourself in communications with your client about what you're telling them about the case, and just try to always make sure that they understand what you think might happen in the case isn't necessarily going to happen, but that's what you're working toward, rather than promising an outcome. Written agreement should reflect what was agreed upon. If the court asks you to draft something after a hearing to reflect what was discussed in that hearing, make sure that's, get the transcript and make sure that's everything that's in the written agreement. Order should reflect rulings, same thing. Don't delay the settlement of a case for the sole purpose of gaining an unfair advantage. So, don't drag out litigation. Good faith efforts should be made to stipulate to undisputed matters. If things aren't in contention, get them off the table just by stipulating to them. Don't have ex parte communications with a judge. Don't send correspondence to the court that the court doesn't need to be involved in. If you happen to get a nasty email or a nasty letter from opposing counsel or something like that, you don't need to forward it to the court with your own note. You can respond to it, deal with it in a professional manner, but the court doesn't really need to be involved in that unless things escalate to a point where they may. Like I said, advise your client that you reserve the right to grant accommodations to the other side if it doesn't prejudice your client. Obviously, if they're sitting in jail, you don't want to be giving too many extensions, because I'm sure that is frustrating for all parties involved. But consider what the request is and whether or not you can agree to that without prejudice to your own client. Try not to enter default without the other, I'm just picking a couple out here. Oh, and number 20, if you do happen to have staff, make sure they understand these responsibilities and obligations too, so that they can, use that when they're communicating with everybody as well. Some of the rules of professional conduct that directly overlap with these standards are Rule 2.1 of the Rules of Professional Conduct require you to exercise independent professional judgment and to render candid advice. Like I said, this ties in with not making their case your case. You need to be objective about their case. You need to inform them of risks with various courses of action. You don't want to become, zealous with something that used to be in the Rules of Professional Conduct. It's not actually in there anymore. It's not in the preamble. You are to represent your client in the best manner for them, but making it almost personal for you, I think, clouds your judgment, clouds your objectivity, and can lead to poor results for the client. So keep things professional, even if they, are fiery passionate about a certain issue or something like that. Make sure that you're not just pressing that issue because they want you to. Don't assert some sort of claim before the court unless you have a good faith basis for doing so. And the good faith basis is probably not just that your client really, 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 really wants you to file that. We get tons of complaints where people who are incarcerated say, I was hounding my attorney for a year to file this particular motion and they didn't do it, and that should be a rule violation. Well, it's not a rule violation if you had a very good reason, good faith reason for not filing something with the court, because you couldn't substantiate it, because there lacked evidence, it didn't have any merit to it. So I would say, stick to your guns in those situations. Don't just file it because they're demanding that you do. That ties into the next one, 3.1, about meritorious claims. Make sure they are, and it's not just something your client wants you to do. Try to make whatever efforts you can just to expedite litigation. I know sometimes that might not be up to you, and I might have to do more with the prosecution, but try when you can. Don't lie or mislead the court. That's an obvious one, which ties in with civility and professionalism. Be fair to the court and opposing party. Don't lie to third persons. So if you're, talking to witnesses, you're talking to other people who are not directly involved in the litigation or the case, just make sure that you have honest representations to all of the people involved. Even in situations where you might be investigating someone or investigating your own client to find things, don't lie on the internet as part of that investigation. Like, you can't go undercover. So don't create like fake Facebook profiles so that you can try to gain information about people. We're not lawyers aren't private investigators. We're not allowed to misrepresent ourselves as we try to do our jobs. If you want to hire somebody like that who can gather that information, that's fine. But you can't be the one that is putting yourself out there with misleading information in order to try to investigate something. If you're dealing with a party in the case who's not represented, the advice you can give them is that they should seek counsel as well. Try not to give them legal advice. Try not to use means that embarrass or delay or burden the other side, things like that. And something that I hope is obvious, try not to engage in fraud, dishonesty, deceit, or conduct prejudicial to the administration of justice as you're representing your clients. Those are, dishonesty and deceit and misrepresentation are certainly rule violations which lead to harsh sanctions. It's not just like when you forget to return a phone call from a client or something like that. Those are generally things which are going to end up in suspension territory. So be really careful about what information you're providing to people, and just be honest about your dealings with people. So as I was saying, the rules do now have a direct tie to the rules of professional conduct now have a tie to the standards of professionalism and civility, where if, sorry, it's not the slide I wanted. So comment 3A to rule 8.4 states that an egregious violation or a pattern of repeated violations of the standards of professionalism and civility may support a finding that the lawyer has violated paragraph D. Paragraph D of 8.4 just says that you've engaged in conduct which is prejudicial to the administration of justice. Now, this is fairly new. We haven't prosecuted a case based on this. I don't know what courts will find egregious at this point. I think in order for us to bring a case like that, we would want to see definitely a pattern of repeated violations of these things, so that we felt that there was sufficient evidence that we could file a matter arguing that it was egregious at that point. But like I said, that definition, that case law hasn't been established in this jurisdiction yet. We'll probably look to other jurisdictions which might have a similar rule to see what their courts have decided if a situation like this presents itself. Just a little bit of information about what you can do if you do have somebody that you think is violating the professionalism and civility rules. The Supreme Court, at the same time the standards were adopted, set up a counseling board. You can see here what the requirements were for the board and who staffs it. You can send complaints about standards to us and we can forward it to the board for you. Or you can also just, I think, look at the standing order on the Supreme Court's website about founding these things. And I think that has contact information. I believe complaints can just be sent to the appellate court administrator, I think. And it might even say in this PowerPoint. So let's see. They can take that complaint and try to provide counseling to attorneys so they can avoid similar situations like this. I don't believe the counseling is mandatory, so that may not be a productive avenue for the board. But if somebody doesn't want to go, they don't want to go. But like I said, if it's egregious enough, it can be something where there could be penalties attached to it. Who can submit a complaint to the board? Bar members, judges, or OPC counsel can submit that. They don't take complaints from the general public. Only if they file something with my office and we think it needs to be forwarded, we can forward it on for them. But they can't directly complain to the board. It's a fairly informal process. They can kind of address these as they see fit. It's confidential. And then eventually the board can written a written advisory to the lawyers involved and also notify OPC counsel if they think it actually impacts one of the rules of professional conduct. They can meet with them, they can try to counsel them over the telephone. And sorry, I'm just skipping through. They can publish matters, confidentiality, in their annual reports to the court, which sometimes also appear in the bar journal. You know, there's always the pages that deal with the disciplinary cases. And if the board has something, they can report on it there as well. But like I said, those didn't really have a lot of teeth to them up until the point where there was actually a tie-in with the rules of professional conduct. Just because, you know, I think people that take practice seriously and care about their reputation would be horrified if somebody referred them to the Board of Professional Counseling. But a lot of the people that are engaging in those sorts of rule violations probably don't care at all. And because everything was somewhat, you didn't have to go to any of those, you didn't have to respond to them. You know, I think attorneys would sometimes just brush it off and then eventually receive some sort of letter of caution from the board that may not have changed their practice at all. Hopefully now that they actually can have some repercussions as sanctionable conduct, there'll be less of that and there'll be more people taking it seriously. I'd be curious to know if any of you have ever contacted the board or filed a complaint like that, or if you've, I guess you don't want to tell me if you've been the subject of one, but if you do, go for it. But I hope that these things have increased practice, you know, increased how much we enjoy practice. Because those are really the kind of things that I know always get me down in my cases, is if you're just dealing with somebody who is unprofessional, but not ethically unprofessional, just a jerk. So I'm sure you guys run into that as well. Let me just check on this question, see if I can answer it. Trina, it might be a better question for you. Because I'm not sure about the answer to that.
So the IDC would encourage any attorney to use public or the defender data or some other case management system. But yes, we do help private attorneys get the software and to install it and to educate how to use it. So the answer would be yes. That we encourage anybody to take advantage of that. Let me see what she can add to answer that question.
Just a slight clarification that you do need to be on a public defender contract of some sort to be able to have us provide it for free. That being said, Defender Data has a pretty economical per case model that they make widely available, and it works very well for this conflict tracking purposes. So just a slight clarification, you can have a private practice as long as you have a public defender caseload, we will provide it for you. I hope that helps and is not even more confusing.
Thank you, Joanna.
I really can't stress enough how much doing a conflicts check and having a system that works for you to do the conflicts checks can avoid so many headaches down the line. Not just headaches for you, but headaches for the court system, other people involved in the case. Late discovered conflicts are always problematic. And they're never going to have good results because you're going to have to withdraw from the case. If it is a situation where you do have co-defendants and there's a late discovered conflict, you're going to have to just withdraw from all of those matters. You can't represent any of them any longer. So you're looking at, you know, however big that group is, all searching for new counsel. Maybe once their case has been going for a year or two, who knows? A major inconvenience for all parties involved. Potentially opening yourself up to a malpractice claim, and potentially opening yourself up to rules of professional conduct violations, even if it was negligent because you didn't have a system for making sure that you didn't have a conflict of interest in a particular matter. You didn't do your due diligence to make sure that you didn't in a particular case. So rather than all of that happening to you, I would urge you to use some sort of system where you can get that basic information about somebody, witnesses, things like that, just so that you can run every new matter through that to try to verify that you don't actually have a conflict of interest and can go forward. Even if it pops up that you might have something which could be a conflict of interest, at least at that point you're in the know, and you can then try to evaluate whether or not you can still proceed with the representation. If it's a waivable conflict, if you can still get their informed consent confirmed in writing, at least you know how to proceed at that point, rather than just having no idea that there might be a conflict of interest lurking out there that's going to pop up once you've already undertaken representation that's going to lead to your withdrawal. So I hope if you take anything from this presentation, the most important thing is that relying on your memory to do conflicts checks is insufficient. You really need to be, I think I've said enough. You need to have a system where you can actually look back through the years and see if you do have a conflict of interest with someone. There's not a timeline that makes these things expire. So, you know, obviously if you've represented somebody 10 years ago, the chances of you being adverse to them at this point in the same or substantial matter is not likely, unless it's like a water rights case, because those things go on for like 30 years. But there's not an expiration date on conflicts of interest. So I'd still rather know that I was adverse to this person 10 years ago than to just not have a clue and then have to respond to allegations once I've already undertaken representation. I'd rather not be, you know, stalling my client's case out, having to defend myself in those situations where it's something that I could have known up front and dealt with up front. So that is what I hope you take from this presentation. Because if you have robust systems in place, it really is easy to avoid most of the situations that we see in the office. Because like I said, most of them aren't knowing. There's not a lot of attorneys out there that are aware that they have or are going to have a concurrent conflict of interest and just don't care and just enter into it anyway, luckily. These are all mostly mistakes that could have been caught earlier. And like I said, if you do catch it early and you do want to proceed and you think you can proceed under the rules, make sure that whatever waiver you're having your clients agree to explains the situation and explains the risks, and doesn't just say, there's a conflict of interest case and I'm waiving it, because that will be insufficient to defend yourself against a rule violation. It really needs to be targeted and specific, and let the person know what the conflict is, what the risks might be going forward, especially with co-defendants. The risk might be all of them lose an attorney. Need to explain to them that, I'm not actually sure in Utah, but in some jurisdictions, if you're representing common co-defendants, there's also no privilege that attaches to those conversations. And like I said, confidentiality is an issue, because if somebody tells you something that implicates one of the other co-defendants, you're gonna have to tell that person. And then at that point, you probably can't represent any of them. So making sure you explain these things up front can hopefully avoid a lot of those situations where somebody might raise an issue after the fact. That's about all I had today. Are there any questions that I can answer? I don't have anything in the Q&A right now, but I've got 5 minutes left.
And you're welcome to raise your hand, and I can ask you to unmute. So if it's easier to ask your question in person, feel free to do so.
Got one right here. Do those of us who have previously been public defenders need to be concerned about the sort of conflict that could arise, say, between a public defender client from years ago who could be a witness in a future case? You know, I've got a couple of friends who are prosecutors, and one of them told me years ago that today's client is tomorrow's witness. So, and that's kind of stuck with me. You don't necessarily, you know, you don't necessarily need to be thinking about that. An issue that might come up, though, is that if you're in a position where you needed to, say, cross-examine that person, and you know things from your previous representation that you'd like to ask them in cross-examination because it's bad for them, but you only know that because of the prior representation and it was confidential, you may have a conflict because you can't actually use that information, which would be in your client's best interest, against that person. So if a situation like that arises, I would tell you to look at Rule 1.9 and read the comments to it. That's my other point today. The comments are often way more helpful than the actual language of the rule, especially 1.7. I would read the comments to that rule and see if it is a situation you can navigate through. But if there are things you would like to ask that person that you can't because you only know them from the prior representation, you may have a material limitation on your ability to represent your client in that situation. So definitely something that could arise. Anybody else? I don't see any. Thank you for having me today. It was enjoyable. It's a little weird to do a CLE presentation where you can't see anybody's faces, but I hope that you found it engaging. Should you have any questions, we no longer do an ethics hotline where you can call in with a potential situation, but the bar's general counsel, Elizabeth Wright, does maintain the ethics hotline for the Utah State Bar. So if you find yourself in a situation where you're not exactly sure what to do, feel free to call into that ethics hotline and ask her whether or not what you're contemplating is something that can be done within the rules of professional conduct. I'd encourage you to seek that advice too. Got one more question. Does an of-counsel affiliation with a firm, an independent contractor relationship, constitute a firm? It's an interesting question. Of-counsel is not defined anywhere in the rules of professional conduct. It was generally something that firms were using when somebody semi-retired, that they would still have an of-counsel designation with the firm, but it's not a defined term anywhere. So there was often a question about whether or not people were being misled by of-counsel designations. Well, recently when the court redid some of the rules, they got rid of most of the rules that deal with firm names, letterhead. All of those advertising rules have kind of just been consolidated into one rule, 7.1, which says that in your advertising, you can't do anything misleading. So I would say if you're going to have somebody listed as of counsel, I think the general understanding from lay people who might see that letterhead or that information is that that's a firm, that they are affiliated together. There's some sort of relationship there. It's not just two attorneys that might be sharing office space, but they each maintain separate practices. So my take is that if you're using of counsel, that means that there is some sort of relationship there that would equate to a law firm. Hope that answers that. And if that's all, I think I'm just about out of time.
Thank you so much, Adam. Really appreciate all the information you've provided to us. It's a lot to take in, and we have recorded this CLE, so if you want to watch it again and kind of revisit some of the issues that Adam covered, feel free to do so on our website. It will be posted there within a day or two. Our next CLE will be on May 18th, and it's on the new laws that were just passed this year on the pretrial detention and bail, and how to interact with the rules. So we hope that you can join us then on May 18th. And again, thank you, Adam, and everybody have a good afternoon, and appreciate all the questions and comments. Thank you. Bye-bye.